The concept of restoring contaminated properties is an important aspect of community development that's referred to as brownfield redevelopment. What we're talking about is taking a property that's been abandoned or is otherwise fallow because of contamination and restoring it to a different but economically productive use while providing for environmentally acceptable containment. In the 70s and 80s, major environmental legislation had the unintended effect of encouraging the disuse of contaminated sites while encouraging the development of untouched or so-called greenfield sites. This adverse aspect of the laws required correction when it became clear that tremendous benefits could be found in brownfield redevelopment, particularly for the urban environment. Properties which have been abandoned pay no local taxes. They're also devoid of jobs and cannot spread the cost of existing infrastructure. Furthermore, since they must be restricted, these kinds of properties don't allow community improvements in open spaces. But through brownfield redevelopment, the community as a whole benefits. With a proper structure, individual investors can benefit as well. Michigan's political leaders were among the early advocates to change of the federal laws. In fact, the state of Michigan has led federal law by introducing the necessary legislation to remove the historic impediments to brownfield redevelopment. This was done despite the potential continuation of federal liability. Michigan's legal changes have restructured the liability standards, performed research to reduce site remediation costs, and created financial incentives to institutions to support redevelopment with emphasis on the local level. As a result, developers have moved to take advantage of the incentives and change the enforcement climate. Michigan put together a program in which the economic bottom line is beneficial for both developers and communities with a variety of funding options. These options include special brownfield redevelopment financial incentives, grants from public agencies, and tax increment financing, or TIF programs. The options also include guarantees which provide funding for the following: site assessment, remediation, land acquisition, developing infrastructure, and environmental cleanup. Key changes in the law have restricted liability to those who actually created the problem. Because there's a two-way incentive, brownfield redevelopment can be initiated either by a local community or by an individual developer. According to the Michigan Department of Environmental Quality, a brownfield is defined as, quote, abandoned, idle, or underused industrial and commercial properties where redevelopment is complicated by real or perceived contamination, end quote. On the other hand, greenfields are sites which have not previously been developed and are generally in rural or suburban areas. In principle, these sites aren't contaminated, which means that new industrial development on greenfields might contaminate a virgin site. At least that's the perception. Brownfield redevelopment benefits local communities and states because of the ability to retain or recover tax base, create or retain jobs, or spread the cost of existing infrastructure. It also creates the possibility of preserving open space. Michigan has been a leader in promoting brownfield redevelopment by recognizing the need to provide legislation, guidance, education, and financial incentives. A CDRC study rated 41 existing statewide programs according to 10 criteria: liability protection, cleanup criteria, financial incentives, climate and attitude of state and local governments, state oversight, agreements with the EPA, related policy issues, participation requirements, fee structures, and eligible parties. Funding assistance for brownfield redevelopment is available from a number of state sources, including the Revitalization Revolving Loan Fund, site assessment grants, the Waterfront Redevelopment Grant Program, the Cleanup and Redevelopment Fund, the Coastal Management Program, and Michigan Transportation Economic Development Fund. Under the Brownfield Redevelopment Financing Act, municipalities in the state of Michigan can establish brownfield redevelopment authorities, or BRAs. These are established to aid in local brownfield development through different activities. Authorities may also establish and administer site remediation revolving funds to finance redevelopment activities. These BRA activities are mainly aimed at reducing economic incentives that would otherwise favor greenfield development. Through the Brownfield Redevelopment Authority, municipalities were also allowed to capture tax increment revenue on taxes levied after December 31st, 1996. The BRA can also issue and sell tax bonds to finance their Brownfield plan. These will capture taxes levied for school operating purposes if their activities were approved by the MDEQ prior to January 1, 2001. Historically, Michigan has levied a single business tax on businesses within the state. That tax was amended to extend a tax credit to non-liable owners and operators of contaminated facilities who conduct cleanup activities on their property. Such redevelopment activities may include demolition, construction, restoration, and other activities on the eligible property in the Brownfield zone. On June 5, 1995, Governor John Engler signed into law MERA amendments implementing a major overhaul of the liability structure applicable to the environmentally contaminated property. Unlike federal law, the Michigan law doesn't impose liability under the property owner merely because of property ownership. Liability is only imposed upon those causing the release of contamination. The law provides the conditions under which the liability relief is granted, principally dealing with due care to prevent exacerbation or to prevent movement which would injure a third party. Liability for remediation is imposed generally only on those who own or operate a facility which is, or was, responsible for an activity causing the contamination at the facility. Even the definition of facility was changed to define a facility subject to this law as one which exceeds the residential criteria of contamination. Removing the provisions of the statute which imposed liability on those that merely own or operate property essentially eliminated the strict status liability infamous under CERCLA. Only the owner or operator of the facility at the time of disposal of the hazardous substance is liable. By completing and complying with the baseline environmental assessment procedures, a new owner or operator isn't liable for the prior contamination at the facility.